Yesterday's arraignment of former President Donald Trump marked the first time in our country's history that a former president was indicted on criminal charges. But Donald Trump is more than just a former president. He's a candidate for the Republican presidential nomination, now charged by the administration of the incumbent president. Does that sound odd? What legal and constitutional issues does this indictment raise? And what can we anticipate next? Joining me now to discuss this and more is John Malcolm, former Deputy Assistant Attorney General in the Department of Justice Criminal Division and a former Assistant U.S. Attorney in Atlanta. John, welcome back to the program. Great to see you.
Great to be with you.
So now that we have the indictment unsealed and the former president officially arraigned, what does everything up to this point indicate about Special Counsel's Jack Smith's investigation?
Well, a slight correction to your intro. This is the second indictment against former President Trump. The first, of course, coming from Alvin Bragg, the Manhattan District Attorney. While he has to take those charges seriously because he's ultimately going to be tried before a New York City jury where he's not terribly popular, I think those charges are very weak. I think these charges by Special Counsel Jack Smith are far more serious. So as you said, he's being charged with 31 counts of violating the Espionage Act for unlawfully retaining classified documents that pertain to national defense and national security. He's also charged with obstructing a grand jury investigation by moving around with his co-defendant Walton Nauta those documents to keep them out of the hands of his attorneys who were examining the boxes in his possession to find documents that were responsive to the grand jury subpoena. And he's also charged with making false statements. There are a number of defenses that the former president is going to raise. The indictment contains statements by some of his attorneys. They're not identified by name, but pretty much people know who they are. So a judge at some point ruled that these people could be compelled to testify before a grand jury under the crime fraud exception to the attorney-client privilege. I'm sure now that the former president and his legal team will contest that designation, try to get that evidence suppressed. I'm sure that they will try to challenge the validity of the search warrant that was executed on Mar-a-Lago, and they will argue that the Presidential Records Act allowed him to keep these documents in his possession, and that as a result, the Espionage Act falls, of unlawful retention, that those charges should fall as well.
So several things there. Let's start with the Presidential Records Act of 1978. That's a civil provision. There are no criminal penalties associated with that, are there?
Yeah. Well, it doesn't even have a civil provision. It sets out what is a presidential record and what is a personal record. And it talks about a procedure for a president to designate what he believes to be personal records. It defines those terms. And then it says how the rest of the information is supposed to be turned over to the archivist, the national archivist, and how a former president can get access to some of those records. Usually, so that this was enacted, as you said, in response to the Nixon tapes case. Up until the time of the Presidential Records Act, there had been essentially a belief that presidents could keep everything that they had. And President Nixon argued that the tapes were his. After that, Congress passed the Presidential Records Act. It applied first to President Reagan, has applied ever since then. And you normally think about things like diaries and journals, things that were created by the president, not for use of the conduct of government business, like political activities he may have been involved in to try to help candidates from his political party, not things generated by other agencies and not things used for the conduct of the responsibilities that a president must exercise. But we will now see whether that is accurate. We will test the boundaries of the Presidential Records Act.
So just to be clear on what you're saying, the Presidential Records Act was more designed for those personal things, those things that were not generated by other government entities or agencies?
Yeah, it's designed to define what is a personal record and what is a presidential record, and to talk about how each category should be handled.
So under the Espionage Act, isn't there a high level of a burden of proof there for showing that there was willful intent on behalf of the president?
Yes, there is. He could have been charged for gross negligence in terms of the handling of classified information. But as everybody, all of your listeners will remember, Jim Comey came out and said that Hillary Clinton had been grossly negligent in the handling of classified information, but that no reasonable prosecutor would prosecute a case against her. That is why his indictment, Jack Smith's indictment, lays out the steps that the president took to try to move boxes around. It contains some language from apparently a videotaped or audio taped interview in which he says, look, I have classified information here. I'm not supposed to be showing this to you, but I will. All of that will, assuming the evidence exists, be offered to prove that this was intentional conduct and not just grossly negligent conduct.
When you say we're talking about criminal intent, so define criminal intent.
Well, that he willfully retained information that was classified that dealt with national security and national defense information, and that he willfully took steps with his co-defendant to prevent those documents that he knew he had in his possession from being returned either to the archivist or to the grand jury in response to a subpoena that he had received from that grand jury.
Now, some suggest that the president's conversations with his attorneys, which has been that client attorney privilege, obviously, as you made reference to, has been pierced here by the courts, would suggest that he was making reference back to the 2012 case involving Bill Clinton, when Bill Clinton actually argued under the Presidential Records Act that he had right to retain certain things, and that he was asking questions about that, as well as questions about Hillary Clinton and the failure for the government to prosecute her. So are there weaknesses in this case that are being presented against the former president?
Well, we'll have to see. I think that what is referenced in terms of the crime fraud exception is not talking about what happened to Hillary Clinton or Bill Clinton, but the suggestion in the indictment is that he was at least implicitly asking his lawyers to destroy records, and also that he was asking them to sign a false certification that he no longer had classified documents in his possession. So they were being used as dupes to commit a crime. Those are the allegations. That's
Right.
not evidence.
Right.
But those are the allegations that I'm sure the judge relied upon in finding that the crime fraud exception applies.
But the counter to that was that Hillary Clinton, her attorneys actually removed many emails, deleting many emails from her bathroom server.
Yes, no, absolutely. Look, I think that Hillary Clinton should have been charged.
The issues with Hillary Clinton that the Department of Justice failed to pursue. Go ahead and finish.
Yeah. Well, there's no question that they failed to pursue it, and her attorneys helped her by destroying. They went through the information on her server and turned over whatever they wanted to turn over, and then they destroyed her cell phones that contained text messages and bleach bit her server to wipe it clean. The FBI never went in to grab that server or grab those cell phones. The context in which this comes up in the indictment, though, and why it was included in the indictment, is that he is telling his attorneys, allegedly, look at all of the things that Hillary Clinton's lawyers did for her. You should do the same things for me. The implicit suggestion is that they should destroy any records that they find that might get Donald Trump.
And I can tell, and I appreciate this, John, because we want justice. We want what is right to be done, regardless of who it is. Justice is to be blind. I think the concern that many Americans have, not defending what we don't know, what Donald Trump may or may not have done, but it doesn't look necessarily good.
Right.
But is there a double standard in our Department of Justice?
Well, the FBI and the Department of Justice have certainly led with their chin, and many people believe that, not only because of Hillary Clinton, but how they're treating President Biden now with respect to allegations that he held classified documents, which we know who did, allegations of bribery, how they conducted the alleged Russian collusion investigation, Operation Crossfire Hurricane. John Durham just issued a scathing report about that. So the FBI and the Department of Justice have a deep problem, in that many people believe that they are not dispensing justice in a politically neutral fashion.
And my take on this is that we are at a We're at a very critical moment in the history of our nation that if we lose as a nation that is ruled by law, if we lose our appreciation for the law and for justice, we're like any other third world country.
Yeah, we are. These are uncharted waters, and they're very dangerous waters. And I'm afraid it's going to get better before it gets worse.
Well, a lot to ponder. John, I want to thank you so much for joining us. And I got to run, but appreciate your insights today.
Thanks for having me on.
All right, John Malcolm, former Deputy Assistant Attorney General in the Department of Justice's Criminal Division. And again, I want to be very, very clear. I don't know all the facts. I mean, I don't know what the president may or may not have done. And we do need to advocate for justice, for truth. The Lady Justice is blind. Doesn't matter who it is. And that's what we should strive for. And that's historically what our country has been about. And I'm not saying it's been perfect, but generally speaking, it has been better than most. And this is what really is troubling for many Americans, troubling for me. When I see what Hillary Clinton was able to do and get away with, what I see right now, and we're going to be talking about this in the days ahead, what he made reference to with the Biden family and the bribes and the payments. And now we hear from Senator Chuck Grassley that there are recordings of conversations with then Vice President Biden regarding these issues. But yet the FBI has been sitting on this, not only refusing to investigate and pursue it, but keeping it from Congress that has oversight of the Department of Justice. Here is you want to know my recommendation, what we need to do going forward? First and foremost, we need to be praying. This is a critical moment. Our nation is divided, and this could split our nation irreparably. I mean, we may not be able to bring this country back together. The danger that we are facing right now, as John said, the uncharted waters. We need to be praying. We need to pray for truth to prevail, for those deeds of darkness that have been done by whomever. I don't care what party label they wear. We need to pray that those things are revealed and that the truth would come forth and that justice would flow down like a river in this country once again. These are indeed dangerous times. And I just caution you to not get wrapped up in the anger and the angst of the moment. I'm angry. Yes, I am. I'm angry at what I see this administration doing to this country. And we're going to talk about this whole agenda that they're pushing to our children, both here and what they're doing abroad. We talked about that yesterday with the whole LGBTQ foreign policy agenda that's being pushed by the Department of State. In fact, I spoke last night in New Orleans at the Southern Baptist Convention. We had a panel discussion, and Mike Pompeo was there, and we had a conversation discussing this on the side, but talked about the national security implications of what's being pushed by this administration through its foreign policy, promoting this ideology that most nations find repulsive. That we're pushing some of these nations that are dependent upon our foreign aid, and we're tying, whether or not they'll change their definitions of human sexuality and marriage and abortion and climate, the trifecta of the left. If they won't change their policies, we're withholding federal funds, foreign funds. And so we're driving many of them into the arms of communist China. Because China they're bad, believe me, they're bad. But they don't push this agenda that is morally repulsive to so many nations that have a religious foundation. So I understand the anger and the angst, but first we need to pray. And I go back to what we say, pray, vote, and stand. We need to pray for our nation like we've never prayed before. We need to vote for men and women of deep moral conviction. Because if we want righteous government, we have to have men and women who understand righteousness in those positions of government. And then you and I have a responsibility to stand for truth. We too need to advocate for what we know to be right according to biblical truth, wherever the Lord has placed us.